What's up, Uncool TV gang? Today is the start of the YSL RICO trial. Jeffrey Williams, aka Young Thug, versus the state of Georgia. Back a year ago, Georgia State Attorney Fani Willis launched a RICO indictment on the YSL gang, which included Jeffrey Williams, aka Young Thug, as the head of the organization. And allegedly is a bunch of charges that's in there that tied in a bunch of his co-defendants underneath of the YSL RICO trial. And today, Monday, November the 27th, 2023, is the start of the trial. But as we get into the opening statements on this trial, well, Fani Willis is not on the trial right now because she's doing a whole bunch of, stuff with the investigation that she launched against Donald Trump, former U.S. President Donald Trump. She launched a RICO investigation on Donald Trump, so I'm guessing she tied up in that. So she has her deputy attorney, Adrian Love, covering this high-profile case, RICO trial against Jeffrey Williams, a.k.a. Young Thug. And it's seeming like they are, so unprepared. Let's get right into the video. Don't forget to hit the like button, hit the subscribe button, share the video, leave a comment, hit the bell, and tune in for more videos coming, all the videos that's coming. Let's get right into the trial.
Now, this is the law of the jungle, as old and as true as the sky.
That's Deputy Adrian Love. She's the state's attorney underneath Fani Williams, who is the state of Georgia attorney general, state's attorney. Fani Williams is Georgia state's attorney, and Adrian Love is the deputy underneath of Fani Willis.
And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack.
It sounds like right here, in her opening statements, that she's quoting the Jungle Book, the Jungle, a poem from the Jungle Book by author Rudyard Kipling. I think this is the 1894 edition, the original edition. The original edition. A boy raised by a pack of wolves in the Indian jungle. Let's get into it.
Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with the evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate.
See, I knew that was a quote from the Jungle Book. Let's get right into it.
For where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself.
Well, we about to take a look right here closely and examine the way Miss Adrienne Love is presenting her opening statements. She's coming off a bit argumentative, and that's like justification for an objection. Let's check it out.
The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotics sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker versus the state at 277.
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
Okay, right there, when that attorney objected, he objected on something called burden burden shifting. Now, burden shifting is shifting the burden of proof, means to change the responsibility of proving or disproving a point from one party to the other party. Shifting the burden of proof is used in a variety of legal areas to allow more flexibility in courtroom procedures. And what the attorney is trying to get the 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 judge to rule on is like she can't shift the burden of proof in her opening statements. She's supposed to just keep it plain and simple in her opening statements. And she's not supposed to shift, none of her proof until she's in the argumentative stage, like cross-examining and things of that nature. So that was a good way to interrupt her in objection.
Yes, Your Honor.
Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier? That the burden never shifts to the defendants to prove for certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
See, this what you get when the state is all over the place in a trial. They wanna attack these big, globalizing cases, but they're really not ready. And like it's seeming as if Miss Adrienne Love has been, put to the test of can she work on the fly by Miss Fannie Willis, and it's looking like the state is all over the place due to, the fact that they didn't even have all of the motions ready, in court when the defense was asking for all of the paperwork and all of the motions to be ready to present the case to even start trial today. All of those things were supposed to be turned in by Friday. So now she's in opening statements, and she's opening statements with shifting proof all over the place. Let's get back into it.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The last paragraph of that poem that I read or spoke to you earlier goes as follows. Because of his age and his cunning, because of his right
This
and
is
his
argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, sir.
All right.
See, even the judge had to agree with the defense that she coming off a bit argumentative, and is like, okay, how much of this do we have to endure before the judge actually steps in and, tell her sustain her argument so she can readjust her wording. But it seems like the defense has to know their law in order for the judge to realize what's really going on, even though he knows what's happening. He's not going to say anything unless the defense is on top of their game. So that was another good objection, because she's trying to argue her opening statements instead of keeping the proof in place, of just keeping the proof in place without shifting the proof. Let's get back into it.
The evidence will show defendants that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they called him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members.
It's looking like she just prepared her opening statements through the night, stayed up all night trying to prepare her opening statements without even going over it with anybody on her team. Because if she'd been doing this job as a deputy attorney, she's supposed to know what's going to fly with a veteran defense, as such as the defense that's representing these defendants on this YSL RICO trial. It's just seeming like she's just trying to argue her opening statements.
You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group.
Quick sidebar. The If family, the Inglewood family gangster bloods. They from out Los Angeles. And they was formulated in the 1970s as a rival gang to the Crips.
Was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies. 2015. Gunned down. Openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. Who's on trial before you today is Rodelius Ryan, Flamarius Nichols, Marquadius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
Do you have an objection?
Yes, sir.
Basis.
A motion.
Okay, now it's looking like it's too many objections in her opening statement, so that's a cause to remove the jury out of the jury box so the judge can get down to like what is going on right now. Like, it's too many objections in his opening statement. You all over the place. He's coming in the middle of an opening statement from the state with a motion, which is not likely to happen unless one of the parties are unprepared with their statements. Let's get into it. Hit the like button, hit the subscribe button, hit the bell, leave a comment. Uncool TV. I love you guys.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters jury deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder, and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So, yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit.
See right then and there, Mr. Brian Steele, which is Jeffrey Williams, a.k.a. Young Thug's attorney. He's smart. He went right after the juggler. He went straight for a mistrial due to her lack of shifting the burden of proof from one party to another party. She did not disclose those slides that she's showing on the screen in her opening statements, and it's trying to shift the burden of proof by having his name attached to him actually representing one of the the defendants in the past. Now we talking about a trial that's going on now in November the 27th, 2023. We're talking about a RICO trial that's stimulating back from 2013, 2014. So it's likely if he's their in-house attorney, then he represented multiple people, you know, that's dealing with Young Thug and whoever else that's surrounding him. So with her attaching his name to her slides without letting him know is like trying to, you know, discredit the lawyer all and out, and that's not fair in the courts. It's shifting the proof from one party to another party.
And it is next court exhibit in order of the state's presentation anyway. So, all right. So that'll be court one for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
See, she's supposed to got all of this stuff over by Friday. I watched this trial on Wednesday, November the 22nd, 2023, and the judge deliberately said that he want all motions, all evidence that's going to be admitted inside of this trial, because trial is going to start today, November the 27th, 2023. Everything was supposed to be submitted by November the 25th, 2023. And now we in the middle of court in front of a jury with a jury in a box in her opening statements, and here you got her bringing up a slide that she didn't even share with the defense attorneys, and it's seeming like she's just trying to just bombard them with things to off-throw them. But mind you, these defense attorneys is sharp enough to know when to object her, and by him coming out filing a motion in the middle of the court, he didn't do it in front of the jury. Notice he held his tongue. He didn't do it in front of the jury. They released the jury from the box. Then he did it in front of the state's attorney, the judge, and the other defense attorneys. And he went straight for a mistrial, which is permissible underneath of what she's doing in court right now. Let's get back to it.
It relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury. I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I would never said this, ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. I don't know if anyone else got that exhibit. I did not get that exhibit. And I see everyone say shaking no. And now it goes against the court's order. We are bound, duty bound, to follow this honorable court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about, because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did.
See, she's so not ready that she don't even know what's on her own slides. She talking about she heard him object and she didn't initially know what he was objecting for, and then she looked at the screen and saw a part of his name on the screen. Okay, what are you doing? Now the judge talking about he ruled on that last week. He's saying to himself, why didn't you go over your slides to make sure his name or nothing daunting would be in there for this objection in front of the jury? Like, come on, Miss Love. I understand that this is a big polarizing case, but you got to do better. You're in opening statements, and all of these objections is like you're holding court up now.
That we were not, I would take it as it came in this case, and if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have the...
all right.
See, even the judge is getting fed up with her. She's just not ready. She's just not ready. I'm going to say that again. She's just not ready. And it's like, you're holding court up. Like, if all of this stuff was supposed to be in by Friday from Wednesday, it's like, okay, we realized that you had Thanksgiving dinner on Thursday, but you're supposed to got right back to work on Friday morning and had all of this stuff ready and over to these defense attorneys so things like this wouldn't be happening in front of a jury in your opening statements. Come on, Miss Love.
The slide.
Pull up, now,
I have it now. I'm
court
about to
has
share this.
court one for purposes of the motion for mistrial.
Look at that. Part of his name, his whole name on there. His whole name on there. Only thing missing from his name is the Ellen Steele. His whole name on there. Represented by Brian Steele. Come on, Miss Adrian Love. You got to be more prepared than that. I thought you was a deputy attorney. Come on now.
All right. Okay, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a re-occurrence report for my mistrial before the next process goes on. I'd like you to
See, Mr. Brian Steele is smart because what he did was he objected in the middle of her opening statements, and he filed for a motion for a mistrial, and is all on the record. So no matter what's going on, everything is on the record. That's what he really wanted to do, was get it on the record.
That now and preserve the motion for mistrial.
You made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacted through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So that's
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right. All right, Ms. Lowe.
Yeah.
Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation. And just like this, so I assume that what you told our jurors is what you expect the evidence to show? Yes?
Yes,
All right, so
definitely.
I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in open you haven't shown to defense counsel? He's
I don't
telling
mind
us,
sharing.
well, I said that. I told you to do that a week ago.
Your Honor, thank you
Because
for asking.
See, listen, that's why the judge is so mad, because I just told y'all, I watched this on Wednesday, 11/22. He told her to have everything in by 11/24, and it's like, here we is on 11/27, and she still don't have it. She still don't have all of her stuff, and now the judge is getting frustrated. He like, is you going to present this case in a professional manner, or are we going to have to sit through your opening statements with all of these objections and people filing motions and people don't have the proper, the proper documentations with what you're trying to present? It's like, what is you doing, Ms. Adrienne Love?
He's telling us,
Sharing.
well, I said that. I told you to do that a week ago.
Your Honor, thank you
Because
for asking.
here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all...
Misty Williams is another attorney on a case. Court had already started an hour late, and here she come trying to approach the bench right before the jurors come in, and she want to approach the bench with emotion that she had. You know, she could have been fouled while they was waiting for, you know, all of the jurors to get there. One of the jurors was late for court, over an hour and a half late, so court had to start an hour and a half late. And here, one of the defense attorneys coming with a motion, you know, right before they about to get everything going, and then that slowed everything down for like another 30 to 40 minutes. It's like due to the state's lack of competence with the documentation and things of that nature, it's got this case running off the rails.
You know, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So, have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor.
This is the prime example of not being ready. Like, if you're not prepared, you're not ready. And if you're not ready, you're not prepared. So how can she get anything done in 5 minutes? You know, it's looking like a long road to a mistrial due to the lack of competence on the state's behalf, due to the lack of preparation that the state has done. They've been on this case for a year now, and they get to trial and they still not prepared. Hit the like button, hit the subscribe button, hit the bell, leave a comment. Thanks for subscribing to Uncool TV, and we'll get right back into this messy YSL RICO trial on Tuesday, 11/28. I just wanted to show y'all how unprepared the state is when it comes to this trial. It's looking like they running a dry trial, so, you know, they can see everything they can get away with in the Donald Trump trial, because that's their prize trial right there. You know, that's Fannie Willis' prize trial right there. So, you know, she got, you know, Miss Adrienne Love out here, and it's not Fannie Willis, you know, fault that Adrienne Love is not ready to present her case. You know, once she took over the case underneath of Fannie Willis, it's her job to be ready, and she's not ready. Thanks for subscribing to Uncool TV. Hit the like button, hit the subscribe button, hit the bell, leave a comment.